Thank you so much. And now we get to listen to Dr. Capron, who I believe will talk to us without PowerPoint. Imagine that.
Thank you, Neil. Neil said at the beginning of the introductions that I would present a lot of new information for thought, and I'm going to say that I'm not going to do that. I'm going to try to present some things that I suspect you are all familiar with, but to put them in a different context and to comment about what we can possibly learn from looking at them, both in a historical way and looking toward the future and questions about where this law will be going. I want to take us back basically 40 years to April of 1975, when a 21-year-old woman named Ann Quinlan went to a party, took some pills, we're never sure exactly what happened, had some drinks, and was found unresponsive after she got home, after she was taken home, not feeling well. And of course, you know what happened over time. She did not recover. She was in what came to be called the persistent vegetative state. Her family, after about 4 months, came to the position of saying that they wanted to have the ventilator that was supporting her breathing removed, and the physicians were unwilling to do so. And the reasons the physicians gave is relevant to what we're thinking about today, because they said that the Morris County, New Jersey prosecutors had said that the removal of the ventilators would be homicide, criminal homicide, and that they would be prosecuted. And of course, they weren't interested in doing that for that reason. So the Quinlans went to court, and about a year later, the 31st of March of 1976, the New Jersey Supreme Court granted their appeal, saying that the right of privacy, which had been recognized in the context of Roe versus Wade, was broad enough to encompass their request to remove Karen's life support. Now, it was said by some of the neurologists, Fred Plum and others who examined her, that they were not convinced that she wasn't going to be able to breathe on her own, and indeed she was able. What made the story particularly poignant is that she lived for another decade until 1985, and when Joe Quinlan was asked about his willingness to withdraw the respirator and was asked would he therefore withdraw the feeding tube, he said, "Oh no, that's her nourishment." And he wouldn't think of withdrawing the feeding tube. Now, in the process, the New Jersey Supreme Court launched something that has now become a commonplace part of all the hospitals, which is hospital ethics committees, because the ethics committee, it was said, would have to approve the decision. That was, however, we should remember, a judicial ruling in that case, and as Neil already mentioned, is not something which is characteristic of most withdrawals these days. Now, that case raised for the public and for medicine and for the organs of the state, both the courts and the legislatures, a number of concepts. One of the concepts was, well, what is the professional position? What's the professional tradition on an issue like this? Is there a difference between withholding care and withdrawing care? What is a terminal illness? And what is extraordinary care? That last point was a matter of a great deal of confusion at the time, because many people thought of it in terms of the complexity of the care and so forth. But it was clear this was actually a concept borrowed from Catholic moral thinking, because the Quinlans themselves were Catholic, and it had come up in the court in their case that it really meant it's something that is disproportionate. And the thought was that certain kinds of care, given the outcome that's possible, are disproportionate. Yet within 15 years, by 1990, and the decision of the United States Supreme Court in the Cruzan decision, which recognized the previously expressed wishes of Nancy Cruzan not to be tube-fed and kept alive if that circumstance would ever arrive, was also had to be legally respected. And so an individual who has lost power to make decisions could have that former wish acted on. In other words, the law came to rest on the ethical principle of respect for persons, the authority of the individual over his or her own body, which includes the right to have possibly effective care withdrawn or withheld, and really said that there was no difference between the two of them, even if doing so would lead to death. It seems to me that at this point, in the late 80s, early 90s, we see the topic of end-of-life care from a legal perspective, and I think from a clinical perspective, branch into four separate branches. The first was the development of extensive means to allow people, while competent, to control the care that will be given to their body when they are no longer able to express their wishes, and that had already existed as an idea with the living will going back to the 1960s. The living will on its face was not a legally binding document. And so over time here in California, shortly after the Quinlan case, the adoption of our Natural Death Act, which revealed in the legal language a great deal of ambivalence over what should be going on and when. But then that presidential commission that Neil mentioned that I directed was the origin of the idea of the durable power of attorney for healthcare, focusing not on choosing the moment and circumstances that one would want to die, but rather choosing the person who one would feel comfortable making that choice. And over time, that whole idea of an advance directive got federal imprimatur through the Patient Self-Determination Act, really giving recognition to whatever law a particular state had adopted, and saying that hospitals and other care settings had to make sure that patients were aware of those rights. Now, all of that may seem very obvious, but in fact, there remains a good deal of controversy at a philosophical level about why it is that, if one thinks of it as we often express it, that there has been a real change in the person once they've become severely compromised or unconscious in a permanent way. Why another person, their former self, is the one who makes those choices. And there is a lively debate about whether the choice should be made based upon whatever I write down on a piece of paper today, or what seems to be my interest at some future time. Now, the second stream really arose in the 1990s as conflicts started to come up in which physicians were not, as they had been, the impediments to discontinuing care, but now were the ones urging that the care be discontinued. And we associate this with the idea of futile care. Doctors and nurses saying, it's futile, why do we have to go on? Very often in circumstances where it wasn't the patient who was speaking, but rather a family member on behalf of the patient. And we now have, in many states, we have here in California, a law which doesn't put it that way, but talks about non-beneficial care. Now, that term may seem slightly preferable, but neither futile nor non-beneficial has an obvious meaning. And it certainly is a subjective term. What is beneficial? What will not lead to a worthwhile result? So that's the second stream. The third stream is the rise of palliative medicine and of practitioners' role in managing the dying process. As you heard, that really began separately from hospitals in hospices, which were identified with a name that goes back to an earlier era, and the original interest in this came from people outside the medical system, but as Dr. Puri has just told us, is now a combination of what happens with palliative care in the hospital and at-home hospice or other non-institutional hospice. But it's important to notice that as part of that, doctors practicing this kind of care have taken further steps and have gotten to the point of comfort with things such as inducing a coma in a patient whose level of comfort cannot be maintained without that. And so this is a form of terminal sedation, or for that matter, managing the care of a person after food and fluids not artificially provided, but provided by mouth, have been stopped because it doesn't seem as though the patient is deriving benefit from continued life. Notably, outside of the occasional litigation, as Neil mentioned, these kinds of things now all go on routinely and non-controversially. Ethics committees do not look at most of these cases. They look at the few cases where things are broken down, and often when there are misunderstandings, sometimes induced by different physicians telling the patient different things, as physicians often talk about their own organ. Oh, the kidneys are fine. Yes, everything's fine. The patient's about to die of cancer, but the kidneys are fine. Well, that's what the family hears is the patient is fine. It doesn't mean, however, that there is anything other than a great deal of discomfort with all of this. Now, I want to relate those three different streams to what has happened with the movement for euthanasia and physician-assisted death. And what I want to do is to bring to your attention the ways in which that is very different from these other things. And I'll go through these quickly. First, it is situated in a criminal law context, not only as an exception to the prohibition on assisting suicide, but by creating a whole bunch of other crimes. Secondly, it is burdened with a lot of detailed paperwork that doesn't apply to any of those other streams in death and dying. And if we want to know why the percentage in Dr. Puri's study, and I know we have a similar sort of percentage from what's happened for ongoing work that's being led here at UCLA, I would say let's look at the way we've singled this out and burdened it with a lot of paperwork. It may be very suitable paperwork, but it may also help to explain why a lot of physicians say this is different and I'm not comfortable with it. Another thing is the action versus inaction distinction, which we've totally abandoned in other areas of dying, is very active here. And let me just give you an example. Suppose we have a patient who is simply too weak to take the pills that have been prescribed. Cannot do that physically. Can't pick up the pills, can't pick up the glass of water, just physically can't do it. For her physician to do it for her, I believe under the statute is illegal. It's euthanasia. It's not allowed. And yet for many people looking at the situation, I think would find it puzzling. But that's the difference between action and inaction. The physician is writing a prescription, but the patient is doing the action, and we can go back and discuss how that became the distinction after the defeat of the California initiative back in the early 90s. Then there's the requirement for current capacity. There are no advance directives. The thing that is the cardinal thing about other forms of dying is not allowed. You have to be currently capable. And yet, we know that from the public opinion polls and from some of the examples that were very prominent in some of the votes to allow this to happen, the notion of getting a degenerative disease, a neurological degenerative disease, here we are in the neuroscience research building, is one of the most frightening things of all. And it's the kind of thing people say, I want to have that right. I don't want to go on. You don't have that right. If your disease will rob you of the ability to make choices, you're not covered by the law. And finally, there's the ambiguity on the basis. Now, in the other areas, as I've said, it is clear that self-choice is what is involved. The respect for the person's control over their life, their own decision of whether their life is worth preserving and living. And in some countries, that is the view, but here in California, it's not the view. You have to have a terminal illness. It's not enough to say, my circumstances are not ones that I want to continue with. There's the imminence or unavoidability of death, and that is different from all the circumstances involving prolonging treatment. You don't have to be imminently dying to be able to say, I don't want further treatment, I don't want cancer chemotherapy. Well, without it, you'll be dead. You know, well, we might be able to save you. I don't want it. No one says, oh no, you're not permitted to do that, because with it, you could live on a long time. It's interesting under the law, which talks about incurable and irreversible, whether anyone is going to be concerned that something isn't necessarily incurable if enough efforts were made. And finally, as was mentioned by Dr. Ganzini, the existence of pain is often talked about in public discourse on this. The notion that no one should suffer irremediable pain. The governor said that when he signed the law. We now had a law so no one would have to suffer pain, a painful death. But in fact, painful death is not required, and painful death is not the reason for the use of the statute. It's all about desire to be in control and to have a certain end of life as you had control during your life. So looking to the future, what are the implications of the normalization of this practice? I think we have to be aware of the risk of a pendulum overswing. Almost every change in the law is dealing with a problem over here, and we get the pendulum swinging, but it doesn't come to a stop in the middle. From the presumption of doctors never ending life by aiding a patient directly to die, and other people only doing so if they have a very strong reason for doing so, we now will have, in effect, the opposite presumption. You would need a very strong reason as a physician if you have the capability and a patient who qualifies. Why aren't you helping them? The law allows you to do it. Why aren't you doing it? We will also remove, the question is, will we remove the requirement for acting alone? I think that this is one point on which there may be a legal challenge. Go back to my example. Why is the person who is mentally capable, but physically incapable of lifting her hand to her mouth or holding a glass of water, why should she be denied the same kind of control over her dying process? Why do we exclude that level of aiding on the ground that it is euthanasia rather than physician-aided death? Will we remove the requirement for certainty and the imminence of death? Why require imminence? What's so special about 6 months? Will we remove the requirement for current capacity? As I say, all across the other areas, the notion of making choices that will bind your future self are accepted. And finally, what would happen, and this is just the thought experiment I want to leave you with, what would happen if we faced someone who said, I want to have physician-aided death so that I can be an organ donor? If the method will not damage my organs, I want to be wheeled into the operating room, given the pill, I'll put it in my own mouth, I'll take the water, and then as soon as you can determine that death has occurred, which you ought to be able to do pretty quickly and pretty certainly, remove my organs. Does that seem bothersome to anyone? I'll leave it with that and maybe we can discuss it. You want us up here?